Welcome to Breath of Fresh Air, the podcast bringing fresh insight and real talk to the world of dental practice management. Your hosts, Amanda Demora and Sarah Hamlin, are two industry insiders who've seen it all from the front desk to the C-suite. Amanda, the founder of Essential Dental Services, now Daydream Dental, is an operations consultant, business coach, and practice management expert. Sarah, former COO of Essential Dental Services, continues her leadership journey as the COO of Daydream Dental, a cutting-edge dental billing company. Together, they deliver unfiltered conversations on dental office operations, leadership, revenue cycle management, team dynamics, strategy, industry trends, and more. Designed for practice managers, dentists, assistants, and front office professionals, this podcast is the ultimate resource for anyone looking to optimize and elevate their dental practice. Take a deep breath, because Breath of Fresh Air is here to shake things up and help dental teams build smarter, smoother, and more successful practices.
Are you a dental professional tired of complicated contracts and hidden fees when you're ordering supplies? At Frontier Dental, they're making things simple.
With over 40,000 products from over 80 trusted brands, you'll always find your favorite products without the hassle. No contracts, no minimums, always free shipping. Plus, their team is made up of former dental hygienists and assistants, so they truly understand the needs of your practice.
Are you ready to simplify your supply ordering? Use promo code FDBOFA at checkout and get $20 off your first order.
Visit frontierdental.com to shop now and experience a better way to buy dental supplies.
Now, let's dive into today's episode.
Welcome back to the Breath of Fresh Air podcast, where we pull back the curtain on the business side of dentistry and talk about what's really going on in our industry. So we have dental attorney Justin Withrow, who represents dentists, dental practices, and even dental billers in everything from compliance audits to board investigations to contract disputes. So if you ever thought, oh, that could never happen to me, this episode might just be here to change your mind. So welcome to the show, Justin. We're very excited to have you here.
Thank you both so much for the opportunity. Really excited to nerd out for a little bit this afternoon on some dental legal issues.
I already told Justin I was reading through his email about some talking points that we could go over, and I just got really excited because I feel like there is always a lot of stuff flying around on Facebook groups and things, and I think maybe this can quiet some of the noise, and that's what I really want this to serve as, for sure. So, Justin, before we dive in, tell us a little bit about how you got started working specifically with dentists and being a dental attorney.
Yeah, it's an interesting story. So I am a partner at the law firm of Flannery Georgalis. I lead our firm's dental practice group, where I handle everything dental, whether it be board investigations, insurance audits, representing dentists and practices in acquisitions or sales, compliance-related items, business disputes. But it all really started probably about 12 years ago when I was contacted by, he was a licensed dentist turned lawyer. And he did a lot of representation of dentists on contractual issues, but he didn't dip his toes into the criminal waters. And so when I first became an attorney, my practice focused exclusively on white-collar criminal defense of professionals of all sorts of varieties, not necessarily healthcare or dental specific, but really anyone that found themselves under the microscope for white-collar fraud-related activity. And he contacted me, and he had a dentist that was under criminal investigation here in Cleveland, Ohio, and he was looking to partner with someone like myself that handled those types of matters and where we could work cooperatively in co-counseling the representation. And that's really where it all started. And so one criminal investigation turned into another criminal investigation, turned into this lawyer really drawing on my courtroom advocacy skills. And from there, we began working collaboratively on board matters, and really anytime there was a dispute. And as I handled more and more cases alongside this lawyer, my notoriety grew, I suppose you could say, within certainly the Northeast Ohio dental community. And I think the nice thing about the dental community is when they have issues, they like to call on their former classmates or their former colleagues to get recommendations of who they can work with and who can help them in whatever the situation may be. And so from that, it's just gradually continued to expand. That lawyer's no longer practicing anymore. And I'm a bit of a unicorn, if I can describe myself as such, because there's lots of lawyers out there that like to represent dentists in a variety of different things. But for some reason, I seem to be one of the few that likes to handle the messy stuff. The board investigations, the criminal investigations, the insurance audits. And if there's a dispute, I like to run towards that dispute where others like to run away from it. And so it's really been a very helpful way for me to grow my practice by having opportunities to collaborate with other dental-focused lawyers and consultants and billers across the country when they have a client that needs services that fall within my realm of expertise. I know it's cheesy, but I definitely consider myself a unicorn. There are certainly lawyers that handle these types of matters for other professionals, other medical professionals in other areas of healthcare. But when it comes to dental specific, there's really not that many out there that do what I do. And I think it's because dental and the dollars in dentistry aren't quite as large from a reimbursement and insurance perspective as it can be in other areas of healthcare. And so I think that has something to do with it. But I'm glad that, I've found this area where, I can be an asset to the dental industry and to the community and can provide a service that others aren't providing.
All right. So moving on to some of our questions that we have for you, because I feel like we just have so many questions that I think we want firm answers to for our listeners. So
that's pressure right there.
Well, I feel like sometimes in Facebook groups and things, people are really operating in a gray area, and I'll pick your brain on that. But for listeners who might not know, what's the difference between a compliance audit and an insurance audit?
Sure. So compliance audit is really when you're not under the microscope of an insurance company or a Medicaid or Medicare. This is something that you are being proactive in assessing how are our systems in terms of record keeping, documentation, our coding practices, where we're going to be our own harshest critic, or we're going to bring in an outside resource to critique and assess our skills in those areas, so that if we are selected for an audit from a state Medicaid, if you're a Medicaid provider or one of your PPO plans, how would we do? How would we stand up to scrutiny? And if we don't stand up to scrutiny from an internal review, we're certainly not going to stand up to scrutiny from an outside auditor. And so when we do these compliance reviews, the way I like to describe them is, we're the dental floss of compliance. It's something that you tell your patients you need to do regularly, but so often we all know that people aren't doing it regularly. They don't floss every day like they're supposed to, and we're not providing and conducting these compliance checks as frequently as we should. And so we like to come in when, hired to do this, and we essentially role play as if we're an auditor from an insurance company. We're going to randomly select certain records. We're going to critique those records. We're going to provide the practice with a report as to what they are doing well and what they need to improve upon. And then we're going to help, if the practice is interested, in implementing corrective measures, a corrective action plan to improve on those deficiencies. And then if the practice is interested, we will come follow up on that compliance review to ensure that we are making improvement. And we can then look to see if there are other areas that now necessitate improvement that weren't necessarily an area of deficiency during the first review. A lot of practices look at it as an unnecessary cost until they find themselves in an insurance audit that goes poorly. And then they quickly realize that it's just a necessary part of being a healthcare provider in this highly regulated industry.
All right. So if a practice owner gets a letter from an insurance company that they are in network with and that they're being audited, what's the first thing that they should do?
Well, let me take a step back from the traditional audit request letter that a practice may receive. At times, before that ever happens, a practice may receive a letter from an insurance company that they commonly refer to as an education letter, where the insurance company is putting the practice on notice that, hey, Dr. So-and-so, we've been reviewing your claims and you are a statistical outlier for XYZ code and procedure compared to other similarly situated practices within your geographical region. And we just wanted you to know that we're monitoring this, okay? Now, they're not necessarily telling you you've done anything wrong, and you may have been doing nothing wrong. But they're saying, we see you billing a particular code, or it could be a set of codes, at a rate higher than other, and I'm putting this in air quotes, similarly situated practices within your geographical region. And that if we continue to see this type of statistical outlier, then we will likely audit you at some point down the road. Now, they don't say the last part, but that's ultimately what this letter is designed to convey, is you're on our radar unless there's a change in these codes, in the frequency in which you are billing those codes. We're going to make sure that these codes are legit in what we're paying out to you. And so that would be a perfect opportunity to conduct a compliance review, either, again, internally or to bring in outside professionals to conduct it for you. But it doesn't always start that way. Sometimes you just get in the mail that unwelcome letter saying you've been selected for a review. These are the patient records that we would like you to provide us within a reasonable amount of time. And it provides you with the whole set of records that they're requesting. Typically, it's somewhere between 10 and 30 patients, but I've seen where it's, 50 to 100 patients. So,
Yikes.
But 10 to 30 is typically a pretty comfortable range that insurance companies will at least start out with in their initial request.
I'm going to weave this into a little bit here and we'll do a little role play, like what should we have done or whatever. So years ago, I worked with a practice who was audited and their previous office manager had just left and had some interesting billing tactics for sure. So they were audited, asked for about 30 records. And all kinds of things were a little askew there. I think the biggest thing was they were billing crowns on prep date as opposed to seat date. And that was specifically in their contract that everything is to be billed upon completion. Some other weird stuff, like just inconsistency with notes, blatantly billing pans on days that the patient wasn't in, so it would get covered. It was a mess. So in that situation, the office did have to pay back for all of the things that they did not bill appropriately, the crowns, all of that stuff. Is there something that they should have done, or representation that they should have got, or should they have just said, okay, yep, our hands are in the air, we were in the wrong and we're paying back that $10,000 that you want?
Yeah, I mean, look, sometimes we find ourselves in a place where it's, as you said, hands in the air, mea culpa, we will do better. I never like to take that as the sole approach, but look, I would be lying if I said that in every audit that we get hired in, we have strong defenses to every claim that the insurance company is asserting, in their initial findings. Most likely, we're going to have to acknowledge that for one code or procedure or issue or another, that the practice wasn't doing what they should have done. And so in those situations where we're not challenging the finding, what we need to convey to the insurance company is, this is a wake-up call. Here are the corrective action measures that we're taking to ensure that this doesn't happen again in the future, whether it be additional training and education, whether it be reviewing sort of the billing protocol within the practice. We are going to identify corrective action measures, and we're going to describe those measures to the insurance company so that the insurance company understands that from the practice's standpoint, this is a trusted partner moving forward. We don't need to be worried about them. Audits are unfortunately, but at the same time, fortunately, the checks and balances process to ensure that those bad actors are identified, and then the insurance company and other government regulators can address those bad actors as necessary. But so oftentimes, we're not dealing with practices that are bad actors or fraudulent actors. We're dealing with practices that, maybe had poor protocols in place or had no protocols or systems in place whatsoever. And that resulted in mistakes, and mistakes that were compounded and continued for long periods of time. And so more often than not, we are conveying to insurance companies, there's additional training and education that this practice needs, both from a clinical perspective and also the administrative team as well. And so then we're going to ensure that that training and education happens so that, again, the insurance company knows we don't need to worry about this practice. They're now back on the right track. And this is not someone that needs to remain on our radar or needs to be totally visible on our radar. I'm sort of the belief that once you're on the insurance company's radar, you never really get yourself taken off of it, but you can certainly minimize your visibility.
So if a practice is kind of like, okay, yes, we were doing all these things wrong, your suggestion might be to do exactly what you just said and take your penalty and just use it as a wake-up call and improve your systems. And like you mentioned, make sure that they know what you're doing to improve your processes and systems.
Absolutely. And then the biggest part of that is actually like following through with it.
Yes.
It's easy to put it into a letter. It's a lot harder to follow through on the additional training and education of staff or the doctors or hygienists, whoever it is that could utilize some additional training. And at times we've had insurance companies follow up and say, okay, well, you said you were going to do all these corrective action measures. We'd like to see proof of that. And so I always advise clients, these are the things we think you should do. Now tell us what you're prepared to do. They don't always necessarily align. And so I don't ever want to represent to an insurance company, we're prepared to take these corrective action measures if the practice has no intention on following through with it, because that could actually make the situation worse.
Do you come across that very often? I mean, who is out there saying, yes, I'm willing to risk my practice or license? This is crazy to me.
Yeah, unfortunately, it happens more often than you would think. And look, it's hard to be a practice owner, where there are dollars and cents decisions that you have to make on a day-to-day basis. And when I'm coming in and I'm recommending that, perhaps one day every month we pause treating patients so that the staff can participate in training while you're compensating that staff for participating in that training, those can be difficult decisions to make. But again, I truly believe down to my core that 99.9% of practice owners are good people that at times make bad mistakes. There is just that 0.1% out there that know they're doing things that are wrong and continue to do them because there's some financial benefit for doing so.
Yeah. I definitely think there's something to some doctors, they're obviously independent private practices, and that kind of makes them think that they get to do what they want to do because they're the business owner and things. But, when you're signing contracts with insurance companies, that changes things for sure.
Oh, you're totally correct. And they want to have their cake and eat it too at
Yes.
times where, we're the practice owner, we get to make all the decisions. But when something goes wrong, well, and I've heard this before, and admittedly, I hear this less in modern days, but I used to hear it a lot a few years back. I went to dental school to be a dentist. I didn't go to dental school to be a business owner. Well, unfortunately, doctor, you decided to open a practice or you acquired a practice. So somewhere your own message got mixed up and jumbled because you're now a dentist and a business owner, and the buck stops with you. So if staff are not doing their jobs appropriately and mistakes are being made, certainly there's some accountability for that staff, depending upon the egregiousness of the conduct. But ultimately, the buck stops with the practice owner. And that's why it is so important to have proper systems, protocols, and then checks on those systems and protocols periodically to ensure that everything is happening in a way that as a business owner, you can be proud of and comfortable with. And then when not, those deficiencies and you can implement corrective actions to improve them.
Absolutely. I say a lot that there really is, there's no focus on business ownership in dental school. When students are graduating from dental school, I wish there were some more resources for them. I think there are, if that's growing as kind of CE topics and things. And then I joke that for male dentists, there needs to be some more classes on, okay, so you're most likely going to be working with a lot of women, and you need to know how to deal with that. The poor doctors that I worked for, it was a practice of 22 and they were the only males in there, and there's going to be tears every so often, and every time that happened they're just kind of like flailing and have no idea what to do or how to react to that. Yes. Right.
I'm not touching that topic. I have no comment. Yes. Nervously laughing.
Well, you have 2 daughters, so you must be getting better and better and better with dealing with all the girl stuff and emotions and all of that.
Yeah, if they were on here, they'd say I was getting worse and worse, but
that actually could be true as they get older. I'm not sure. My daughter's only 7 months old, so I'm not looking forward to any sassiness or emotional roller coasters, but I know they're coming.
yes.
All right. So now I want to talk a little bit about just going back to Facebook, because I talk a lot about Facebook on this podcast and what I see in dental groups. So I see a lot of, I want to say, people with authority or who have large audiences giving questionable billing advice on Facebook and in their classes. A lot of, yes, you can be in network with insurances, but still do your own thing. Like, you can have patients sign waivers and not bill their insurance or different things like that. So what do you say to some of that advice, Justin?
Yeah. I admittedly, I didn't appreciate until a few years ago that by being focused on serving the dental industry, that also meant that you have to be on Facebook 24 hours a day.
I am with you on that. I didn't have a Facebook prior to starting my billing company.
Yeah, after college, and Facebook became popular while I was in college. And then once I started law school, I deleted Facebook. And then I quickly learned that if you're going to be anybody or have visibility in the dental industry, you're going to be on Facebook and you're going to be a regular on Facebook.
Yes.
And I think there are a lot of great things about the various Facebook groups. They give an opportunity for the fraternity of dentists and those that help dentists within the industry communicate and share ideas with each other. But at the same time, there is a lot of bad advice that is communicated in the various, Facebook groups. And it's hard. It's hard because if you're a person that is genuinely reaching out with an issue, there's nothing that says, well, this advice is better than that advice, unless, you're constantly ferreting through the comments on your post. And so you're left making a judgment call based upon some person that you've probably never met before who's commented on your question. And it could have fairly dire implications for you if you implement their advice and it's wrong. And so I always caution folks that they shouldn't solely rely upon what they read on Facebook as gospel. It can be a starting point. It should not be the end point. And so everything needs to be trust but verify. And sometimes that can be very hard. But I think you have to, rely upon those who you trust to try to identify who your trusted resources can be. And then you lean on them. And I think if you found a trusted resource, if they don't know the answer to your question, they will be able to point you in the direction to somebody that does. And it can be hard, though. It can be really hard. In fact, I was on Facebook this morning and I was tagged in a post about a practice that was undergoing an audit from a special investigations unit of some insurance company. And they had submitted the records and they were understandably anxious and nervous about what was going to happen. And there were a few comments that said, don't worry about it. They just want money. And, I've gone through this and I only had to pay back a couple $100. And that could all be true, but it doesn't mean it's going to be true in this instance because you have no idea what this person's practice's records look like. You have no idea whether they have a history of, adverse events with this insurance company. You really have no idea. And so when people say, what I hate the most is when people say, don't worry about it. Well, they are worried about it. So what else do you got? And if you can't provide practical guidance, then I think it would be great if there were a lot fewer comments because minimizing doesn't actually make the situation any better. It actually potentially makes the situation far worse. And so I prepared a fairly lengthy response where I said, look, this is what could happen. Doesn't mean this is what will happen, but this is how this process generally will play itself out. No absolutes, no definites, but again, here's my experience. I do a lot of these. If you ever want to chat, message me and I can answer any other questions you have. And I think it should be more of that where you're not so definitive in your guidance, but hey, maybe you should look at this or you should consider that in informing your own opinion and decision.
Okay, so you did not do what I usually do, which is type out a long response and then delete it and say, not worth my time.
Well, sometimes I do, not always, but when there are posts specifically related to audits where that is my passion, I don't have the self-control to type out a message and not hit post.
Well, you absolutely should be hitting post because you are the expert. So if you're in network with an insurance company, to what letter of the law do you recommend following your contract? In your eyes, in your expert opinion, is there wiggle room there to say, yeah, I don't like that reimbursement fee they're going to give me for Invisalign, so I'm having the patient sign a waiver and I'm just not right. So yeah, tell us your opinion on that.
No, there's no wiggle room. You sign a contract. That contract has terms. By signing it, you've agreed to the terms and conditions of that contract. Point blank, period. Doesn't matter if you decided not to read that contract before you signed it. By signing it, you have agreed to abide by those terms. And that's ultimately what an insurance audit is looking at. Are you complying with the contractual obligations of that provider agreement that you signed? If you are, great. We're not going to seek to take any money. We're not going to evaluate whether we need to terminate your credentials as an in-network provider. We're not going to seek to pursue any sort of referral to the board or to a state or federal law enforcement agency. We'll go on our way and go check the next practice. But if you're not, then yeah, we are going to identify those contractual errors and we're going to ask for money back because you agreed to do certain things and you're not doing them. So there's this concept of extrapolation. And so and I'm a lawyer, so I'm not very good at math, but let's do some basic math here. So an insurance company requests 30 patient records. And let's use Amanda's example from a bit earlier where the practice was billing on prep date when the contract says you're going to bill on seat date. Well, in 27 of those 30 charts, that's exactly what was done. Billed on prep, not on seat. So we have a 90% error rate. And many times in these provider manuals that folks should pay closer attention to, there's language that says, if during an audit or some sort of utilization review, they like to call it a bunch of different things, but at the end of the day, it's an audit. If we find a 90% error rate, then we can extrapolate that error out to all patients that you treated with that service that are insured through our network for a period of time. And so it could take a $10,000 problem and make it a $100,000 problem. Or in one case where I represented a practice, it went from a $28,000 problem to a $248,000 problem because they were overtly not complying with a contractual term of their provider agreement. The error rate was 90% or above. And the insurance company said, look, we're not going to go through the hassle of reviewing all of the patient charts that for this code that you've built. We're just going to assume that if we reviewed all those charts, we would find the same error. And because we can do that based upon the language of our provider agreement that you signed, again, a $10,000, $25,000 problem can well exceed six figures quickly.
I don't like six figures.
No, very scary, very scary. And that happens. I mean, that happens. And it's those practices that quickly realize the import of reading provider agreements, conducting compliance reviews, and ensuring that we're doing from a documentation and coding perspective what we agreed to do. Sometimes, and I think this is just, the human component of things, we don't really learn a lesson until we get caught. And once we get caught, then hopefully it's a lesson that we're not going to have to learn a second time.
Every time people are like, we bill on prep date. Like, I just can't see that. I gotta exit. I have to exit the chat at that point.
And it's so true. And I hear it all the time too. It's like, well, I know my colleagues who have been doing it this way and they've never faced audit. And it's like, well, then they've just been unlucky and you're unlucky. But that doesn't make what they're doing right. And it doesn't make what you were doing right. You just got caught before they did.
I think sometimes when dentists flock to advice or they see something that's an answer, that's what they wanted to hear. They wanted to hear that they could do it that way and they could squeeze more money out of their patients and insurance. That's part of it. I don't agree with that at all. And like you said, finding the resources and doing your own due diligence of reliable places to get this information is really important. I saw a comment the other day that was someone asking if the locum tenens box on the 2024 ADA claim form could be used for doctors that are new to the practice whom you are in the middle of credentialing. And a reliable source said, yes, that is what it's for. No, that is not what it is for. And It's just, I don't know. I just don't like seeing things like that because it's just, I feel like the dental community is big, but it feels small. And we should
Sure.
really all be in this together and be trying to give everyone the best possible advice and set everyone up for success. And that's really not what some people are doing, whether they realize it or not. But it's frustrating to see for sure. Okay. I know audits are your favorite topic. And we're going to move on a little bit to due diligence in practice purchases. So you work a lot as well with financial due diligence when practices are going through transitions. Tell us a little bit more about that and why this should be on doctors' radars when they're buying or selling.
This is quickly becoming a passion of mine. The lack of clinical due diligence that is done during the acquisition of a practice. So, in fact, I was just on the phone with a young dentist in his young 30s that bought a practice, and the financial due diligence was done. You know, the numbers on the spreadsheet all looked good, and he went forward and bought the practice. But what he didn't know, because there was no chart review clinical due diligence, is that once he acquired ownership of the practice and he started seeing the full scope of the patient records, that there were significant deficiencies in documentation. There was substandard care from his perspective being provided, open margins on crowns, excess decay being left, things that were very problematic from his perspective. Had any sort of clinical review been conducted during the due diligence phase, these things in all likelihood would have been identified. They would have had an impact on the purchase price. They might have had an impact on whether he wanted to proceed with the acquisition at all. And certainly it would have impacted on provisions within the purchase agreement, like rework and other provisions that without having conducted that clinical review, you're not thinking would be necessary or appropriate. And so now we have a young dentist still dealing with a mountain of debt from dental school, now has doubled or even tripled that debt by acquiring a practice. And they're left questioning, did I just make the biggest error in my life? Like, am I going to have to contemplate some financial catastrophe because these patients have not been well treated? And I've now that I've been the practice owner for 6 months, I'm incurring over $100,000 to this point of rework that, based on the language of my purchase agreement, I'm not entitled to seek to claw back from the seller. And this is but one example that, of conversations that I've had with new practice owners where clinical due diligence is not being conducted. And I say oftentimes that if you don't know what the financials of a practice are built off of, then do those financial numbers actually mean anything? If they're built off of deficient records, substandard care, do those numbers are they accurate? And my position would be they're not, because you wouldn't buy this had you known that under the hood there were all these problems.
Yeah, I think we've talked to and worked with a fair amount of new doctors buying older practices and definitely seen some issues there with AR and what the agreements were when purchasing the AR. And I always I'm not an attorney, but from my standpoint, always implored them to dig a little bit further into the AR than what's like on surface level. Like, yeah, okay, maybe you're purchasing the AR, but I bet none of it is even collectible.
Right. Exactly.
Right.
Exactly.
So yes, please purchase this AR at whatever fraction of the price they might say. But That is always my recommendation. And even then, I've seen some weird things go on after the sale goes through with the previous doctor. But as the new purchasing doctor, you don't know what you don't know. You've never
Exactly
been
right.
in a situation like this, and you have no idea how to run a practice or what really goes into it. So I think definitely having a awesome attorney on your side is a really big asset.
Yeah, and it's hard because look, you're contemplating making a significant financial decision at a time where I think most dentists are at the stage of their career are still, confronted with a significant amount of dental school loans. And, they want to have the transaction conducted as efficiently and cost friendly as possible. And again, I think exactly what you said, Amanda, they don't know what they don't know. And so if you don't know what you're buying, you shouldn't buy it. You wouldn't go buy a car without taking it for a test drive, or at least, sitting on the inside of the car, opening the glove box, seeing all the various, toys and trinkets that it has to offer. But so oftentimes in these dental practice acquisitions, they're not doing that. They're not taking a peek inside of the practice, or, they go there, they meet the staff, they walk around, but they don't ever spend any time looking in, a sampling of charts to see if they like what they see or not. And they absolutely should.
Yeah, I agree. Totally agree. All right. One of the other things that you work with a lot too is when the board comes knocking on your door. So,
Yes.
talk to us a little bit about what are some of the things that might trigger the licensing board to send you a letter or investigate you, or, maybe tell you you don't have enough CE or.
Yeah, I think what's probably the most common in terms of a board investigation is when a patient complains about the services that they were rendered and that they received. And oftentimes, when you peel back a few layers of the onion, it has more to do with the costs of those procedures and what they have to pay than necessarily the care that they feel they received. And look, I know that at times we can all feel like boards are too aggressive in how they oversee and regulate the profession. But the board also recognizes when there is a complaint warranting investigation and those complaints that don't. But at the same time, that doesn't mean as a dentist or the practice owner, receiving this letter from the board about a complaint that you should dismiss it out of hand. I have the mentality that anytime we are being asked to provide an explanation of work we performed, services rendered, I want to make that investigator actually be frustrated and annoyed that this patient had the audacity to file a complaint with the board. So we want to kill a fly with an atomic bomb. So we want to put together as detailed and comprehensive a response to a complaint as possible, providing them with all the documentation, because we're all going to have great documentation practices. And we're going to be able to prove to the board investigator that, this is what this is really about. The patient just doesn't want to pay for the service. There were no issues here, and this doesn't merit any further investigation. And I would say 9 times out of 10, that's exactly what happens. Now, sometimes a board receives a complaint that is totally justified. And in those instances, it's all about sort of falling back on the same things when, we're having a mea culpa in an insurance audit. At times, we need to be able to recognize if we've done things improperly or substandardly. And we need to, again, assure the board that this is not something that necessitates disciplinary action. This doesn't necessitate some sort of public disciplinary action that will then be reported to the National Practitioners Data Bank and will be a ding on my license for the rest of my career. And in those instances, we have to really prove to the board that we've taken the necessary steps, again, to ensure that whatever has happened isn't going to happen again. Now, sometimes that's not enough. And sometimes providers have engaged in conduct that is going to necessitate some sort of publicly visible discipline on their record. But we always endeavor to try to resolve any sort of disciplinary complaint or investigation without there ever being any publicly visible action on that provider's license.
What do you think some mistakes might be when a dentist tries to handle all this themselves, like, dealing with the board and stating their case? Are there any things that they do that might be a misstep?
Okay, we're going to take a quick break from today's convo, but don't skip this part because we want to talk about something that's actually made a huge difference, especially in my practice's bottom line, and that is supply ordering.
Oh, yeah. Okay. No, I remember you telling me this story. You were saving a ton of money. And who were you guys using again?
We switched to Frontier Dental about a year ago. I have been loving ordering from them. Their website is super fun. Each product has 360-degree views of products, which doesn't sound like a big deal, right? But when you're trying to figure out that exact pointy, extra fine burr that your doctor wants to order, or some obscure dental instrument that you've never heard of, you want to make sure that you're actually ordering the right thing.
Yes.
So I've been loving that feature.
In those instances, the 2D magazine picture that's, hand drawn by somebody else does not cut it when you need to find that specific burr. And I have obviously been there in my offices too, where we've ordered the wrong thing because of that catalog. And then you have to do the whole return shuffle, wait for your rep to come, pick it up. Maybe you'll be able to exchange it. Maybe you won't. It's just such a headache.
Right. And the pricing is the best that I have found, honestly. So that makes me keep coming back. But besides that, we've now gotten to know their team, and their culture is just awesome. They actually care about their employees and also their customers ordering from them. And it's hard to find a vendor that can combine great prices and support like that. They're constantly reaching out to make sure that our office doesn't need anything or that everything went well. And I've just been super happy. And it's unlike any supply company that I've ordered from before.
I love it because honestly, like with a lot of these supply reps and stuff, they stop by the office and everybody knows them and everybody just feels like they're there to upsell you on stuff, which they sometimes are. But in this case, it sounds like Frontier's really there to support your practice more than anything. And I love to hear that.
Exactly. So if any of our listeners are still ordering from the same old vendor and you haven't done a price check against another company in a long time, please check out Frontier. This is your sign to do it. Their website is awesome. And when we reached out to them to ask if they could offer our listeners a discount, they agreed.
Yay!
So by using the promo code FDBOFA, we'll have that in our show notes. You can get a discount off your first order. Back to the episode.
Yeah, I think they always inevitably minimize the complaint, because they take a look at the records or they remember specifically this patient in this encounter, and they've already made the internal decision that this patient's got it all wrong. The board can't possibly think that I did anything warranting disciplinary action. And so they don't really go into this in responding to the complaint with the kill the fly with the atomic bomb approach.
I really
So
like
they
that
write
analogy.
they write some very short explanation. They may or may not send all the necessary records, and they have this very dismissive approach. Well, that's not going to work, because what the board will pick up on is you not taking seriously the process. And so more than anything, and again, very similar in insurance audits, they want to know that you're taking this seriously, even if you both know that this complaint has no merit. You still have to, appropriately respond, provide the necessary documentation, and be respectful of the process, even if you feel like it's a process that you shouldn't have to be involved in. And when you do that, because ultimately at the end of the day, these investigators have a lot of discretion in the recommendations that they make to the investigative subcommittee of their board. They have the discretion to say, we recommend that this investigation be closed with no further action, or a warning letter, or no, we think that the board should contemplate and vote upon taking formal action against this licensee. And so you want to make that investigator's job and the discretion that they have, you want to make it easy for them to go your way. And so being respectful of the process, providing thoughtful, detailed, thorough responses is really the best way to do that.
Okay. So don't be treating this in a flippant manner, basically.
See, I get paid to talk. So what you just said is totally correct, and what I probably should have said, but yes, exactly right.
Oh, I think you said it a lot more eloquently than me, so we're going to go with Justin's response. All right. The next subject we want to talk to you a little bit about is one of our favorite topics, which is how you help dental billers represent themselves and help them with their contracts and things for their dental practices that are their clients that they're doing dental billing for. So I know I've sent a few over to you, which has been great. You are the expert. I feel like they don't have anywhere trustworthy to turn. So it's perfect. You're a unicorn in that sense too. Why do you think it's so important for dental billers to have solid contracts with their clients?
Well, because there needs to be an understanding between both sides as to what the expectations are, what the biller is responsible for, what the practice is responsible for. And I think most important, the biller needs to clearly articulate to the practice not only what they are doing, what they aren't doing, and if we find things that we disagree with, what bases do we have to end our relationship? Okay. And it's really no different than what I do in my representation of practices. And I think this is why this has been a natural offshoot of my representation of dentists and practices, because so often I am confronted with clients who are doing things improperly or are under investigation of allegations for doing things improperly. Well, what does the biller do who has a client that they provide services to when they discover this practice is doing things improperly? I need to get out of there. How do I do it? And it really starts with, well, what does your contract say? And you need to ensure that there are proper guardrails within your contract to ensure that you have a way out when you find that your client isn't doing things appropriately. And I think it can be very difficult, particularly for folks that have been working in a practice for a long period of time and decided to make this transition to opening their own business. And it can be hard to walk away from a client when you may not have that many clients at this stage. But, what is very real, and I think very important for the audience to understand, is that there is exposure to billers and even third-party billers who participate in improper and illegal conduct. And so when you find that your client is misrepresenting information that you need to rely upon to do your job, or based upon your review of that practice's records and documentation, you see that they are doing things improperly, you need to be able to put that practice on notice of, I have major concerns about X, Y, and Z, and you need to provide yourself a way out if they're not prepared and agreeable to correcting those errors. And it is critically important that we communicate those concerns and those deficiencies that have been identified in writing, because that will protect you down the road if there ever is, a question about your participation or involvement. So you want to create a paper trail to protect yourself when you find these things that should ultimately cause you to terminate your relationship if the practice and your client are unwilling to correct them. And so I get contacted a lot about, I have this client, they're doing X, Y, and Z, and what's my exposure? Or am I at risk? And how can I, broach this subject with my client? Or how should I document these concerns that I have? And these are all very real scenarios that I'm sure every third-party biller that operates their own business or works for a third-party billing company is going to be confronted with at one point or another in their career.
Sarah, have you ever felt more justified in your life? Because this is something that we've always done, which has been great. And I'm feeling like we were doing the right thing all along now.
For sure we're doing the right thing, but like it makes it so hard it's very difficult to stand up to, a client, like Justin said, especially if you have limited clients and you don't want to lose that client, but also, to be the one to kind of break the news to them that like, hey, actually, this is wrong and you can't do this. And here's why, they're just like, well, you're not a lawyer. What do you know? How do you know that this is wrong? Where's the proof that this is wrong? Provide me with something in writing that this isn't, allowed. And some of these dentists don't even have access to their network contracts that they signed 10 years ago for you to be able to show them. So it just is it's very intimidating, that process, I think. So yeah, having somebody that is validating our feelings and what we've been saying is so helpful and important.
I remember
Totally.
The first time Sarah and I came across this, it was someone who had signed up for this, some kind of dental billing membership thing that had questionable advice. And Sarah and I had gone back and forth and drafted a lot of emails, and Sarah was citing sources and things. And we just tried to be as helpful as we could. And luckily, that practice owner took it really well. It was like, oh my gosh, I had no idea. Like, I just stumbled upon this membership and I wanted to use it to help my staff. And I didn't know that the advice in it was trash.
Yeah.
And I do think that's 9 out of the 10 clients, but you're going to have that one client and you're going to have that one experience that is going to leave that sour taste in your mouth for all future encounters. And so there have been times here recently where a biller will engage me to come in and be the muscle, have the fatherly or the parental conversation with their client about, my perspective and why I think, what they're doing is problematic or could be problematic, and just to hear it from another voice. And sometimes that's all it takes, and it's sort of what we tell our kids or what we heard at the dinner table growing up. Like the right thing isn't always the easy thing. But, what I tell my clients all the time is I want to make it easy for you to put your head on the pillow at night. And, if we do things the right way and where we've made mistakes, if we try to correct them, inevitably you'll get a better night's sleep than if you decided to go the other direction.
Yep. You sort of answered this a little bit, but I think for all of our billers, our billing company owners listening, the biggest question that they want answered is, what would happen if a practice was maybe audited by an insurance company and the dentist tried to pass off part of the error to their billing company? Like, oh, that wasn't me, that was my billing company. What kind of liability might they face, and how can they protect themselves from that besides their ironclad contract?
I'm going to give you a very lawyerly answer. It depends. And it does. It really depends, one, on the scope of work that biller does for that practice, the representation language in that contract of what the doctor represents, assuming that there's some language in there that the doctor acknowledges that, the records that the biller relies upon to perform their services are truthful and accurate. If that is the case, I think the level of exposure, now, again, we're talking in very vague generalities here, it is somewhat limited because you're only as good as the information that you're provided to do your part of the job. So if it is being represented to you that the records are truthful and accurate, and you relied upon them and justifiably and reasonably so, then I would think it would be very difficult for a practice to scrutinize the third-party biller and have any success in seeking to have that biller responsible for all or any portion of whatever, financial sanctions that the practice had as a result of an audit. Now, obviously, there's going to be instances where that may not be the case because the biller knew that things were happening improperly and continued to work complicitly with the practice to bill things that they knew shouldn't have been billed or to perform work that they knew was improper. Okay. Now, I think that happens very infrequently, but if that were happening, the analysis may change. Okay. But I think what's also important to remember is that if a practice is doing something improper and the biller is an unknowing participant in it and is justified in relying upon the information that they receive to do their jobs, is the practice owner going to honestly try to file a lawsuit or somehow challenge legally the biller? And they would be forced to acknowledge that, oh yeah, we were doing things improperly and our records were, deficient, but it's still their fault and they should have to pay for that. I mean, it would be a very challenging case to make in front of a court, and where they would almost assuredly have to be acknowledging that they were doing things improperly. So I don't think that's a huge area of risk. I totally understand why it is such a huge area of concern.
Yeah.
But provided that you are doing what you're supposed to be doing, ensuring that you have the proper protections in your contract, making sure that, the right decision isn't always the easy decision, but you're making the right decision, and that, you have assurances and you're verifying that the documentation that you rely upon is truthful and accurate. Okay. And if you're doing all of these things, then I think if there was ever scrutiny about the documentation in which the biller performed their services on, I think there's little exposure for that biller.
Okay. So
That's a relief.
yes. Well, and I like how you said, yes, you understand how it's a big area of concern, but maybe not the biggest area of risk. So I hope that makes people feel a little bit better. And you put it again very eloquently, but that would be a really unkind doctor to try and pawn this off on his billing company.
But it's something that I would expect because, when we're facing scrutiny from an insurance company, from a regulator, everybody is team me before team we. And so they're always looking out to protect themselves, even at the detriment of those who they know didn't have any participation in whatever was being done or should face no scrutiny for what is being scrutinized.
This is sort of along the same lines, but another thing that comes up is when I am coaching I say young dental billing company owners, they ask a lot about what would happen if they were ever to get in trouble or, run into some issues with one of their clients, but they have a 1099 contractor working that
Mm.
account, who is responsible for what? Is it going to be the 1099 contractor? Is it going to be them and their company? Is that something that is really specifically laid out in their 1099 contractor agreement?
Yeah, so I think the answer is both. I certainly think the billing company itself that is employing the 1099 contractor is going to face scrutiny for the work performed by their contractor. Now, that contractor could in turn face scrutiny from the billing company for the work that they performed. But as far as the practice is concerned, it goes back to what I said earlier, the buck stops with the practice owner, right? And so the same is true of the billing company. And I had a situation not that long ago where a billing company employed a contractor, and that contractor wasn't living up to their obligations and wasn't doing what they were contracted to do. And when it had an impact on the dental practice client of the billing company, it was ultimately the billing company that had to, pay for and work to, at their expense, correct the issues that resulted. And to that company's credit, they did exactly that. Now they're exploring whether they have any recourse with that contractor, but that is secondary to correcting the issues for the practice.
Sure.
Yes, one of my coaching clients is in that boat right now. So working her little tail off as the business owner to correct things that, yeah, maybe she should have been watching her contractor a little bit more, but now it's just a mess. She feels bad even billing the client at all, and she's essentially working for free or kind of in the red there. And yeah, there's a lot to this dental billing business ownership thing.
And I would say
Yeah.
the same thing goes if you decide to work with like a temp agency. You need to understand and really make sure you are confident in the language of the agreement that you're going to sign with the temp agency as to who's responsible for what if something goes wrong.
Yeah. You want to know that stuff ahead of time.
Yeah.
You shouldn't be asking it after the fact. That's, kind
Right.
of, I think that's what happens more often than not, but it would be better to be prepared for
By the
it
way,
than to
who's
have
on
to
the hook
scramble.
for that? Yes.
Yeah. Yeah.
Exactly.
Exactly. What we ask the dental practice owners in reading their provider agreements, we should hold ourselves to the same standard and
Yeah.
make sure that we understand whether we're having a 1099 contractor or we're working with a temp agency. We should understand what those agreements say before we sign them.
Yes.
Absolutely. Absolutely. All right, moving on to our last thing here, and that is criminal investigations in dentistry. So tell us a couple scenarios of what might trigger a criminal investigation in our industry here.
I think it falls into those traditional buckets of billing fraud. So whether it be upcoding procedures, so billing a procedure at a higher reimbursable than the procedure that was actually performed, or billing for services that weren't rendered. And I had a client not too long ago that was under investigation for exactly that. So this client was not yet to the office on an early, I think it was a Wednesday morning, if I recall correctly. And they received a call from their office manager who said, "Doctor, I've got some bad news. There's about 50 FBI agents here, and they say they have a warrant to search the office and take computers and take patient records. What do I do?" And so I was quickly engaged to represent the practice. And, clearly there's a sign that there's some concerns here that we need to look into. So, just taking a step away from the legal ramification side of things for a moment, the reputational harm that something like that has instantly, I mean, you certainly can calculate it because what patients that were on the schedule and anticipated fees that were scheduled to be performed are now gone. And it can be very challenging to correct and cure that reputational harm. Because the problem is that these investigations, they can drag on for months and in some instances years. And all the meanwhile, because it's an investigation, depending upon the severity of the allegations, the individual under investigation is likely still permitted to practice and operate their business. Because again, you're innocent until proven guilty. It's an investigation, so there's been no charges filed. And oftentimes, dental boards will not take any action against a license unless there's been some finding or adjudication. Now, in some instances, they will step in and seek to take action before that happens, but that is for particularly egregious circumstances and far from the norm. So going back to this particular client, the search warrant is conducted. They effectively clear out the office. They copy. This practice was still utilizing paper charts, and we're not going to judge for that on this podcast, but that's what they were doing. And okay, we'll deal with that. They took the computers as well. And once we worked our way through getting all of the records back and getting the computers back and just being able to operate whatever semblance of a practice that remained, we had to start figuring out, well, what the heck was happening and where are these allegations based off of? And so this particular doctor, it was a Medicaid practice in rural West Virginia, which try to say that 3 times fast. And so, there he was treating a lot of children. And in this particular area, oral hygiene was not an emphasis at the household. And if it wasn't Mountain Dew, it was meth. And so there were patients that had lots of problems. And as I think, any Medicaid practice would recognize, if you get a Medicaid patient in the chair, you're going to provide whatever amount of services that you can, because in reality, they're probably not coming for their 6-month checkup. And it could be years, if ever, that they come back. And so when you have someone in the chair, you do all the care that within reasonable standards that you can do that's in the best interest of that patient. And that was the philosophy of this practice. And so it would not be uncommon for the doctor to perform, a dozen plus fillings on a patient in one sitting. And this particular doctor was very fast at, prepping and restoring teeth. And so there was a lot of restorations that were being performed out of this office. So much so that he was, I think, if not the highest, one of the highest in terms of numbers of both single and multi-surface restorations. And that's how he found himself on the radar. And so the government was absolutely confident that they had uncovered a practice that was just engaged in rampant fraud for billing services that weren't rendered. Okay. And it can be very challenging to prove that a restoration was performed on a patient, especially remembering back to minor patients, not great oral hygiene, Medicaid insured. So trying to find them was one, difficult. 2, it's not impossible that tooth may not even be in that patient's mouth anymore. Or 3, there's been other services that have been rendered on that tooth, so you would have no way of knowing whether that restoration was done or not. And so these were some of the complexities that we were faced with. And so the government, in investigating this case, had taken x-rays and identified other providers that had seen these patients, and they had gone to these providers with copies of x-rays and said, in the midst of the day, these weren't pre-planned meetings or anything. They're just pulling a dentist out of one of their operating rooms, badges and guns, saying, look at this x-ray. And they were seeking to have them confirm whether they could see a particular tooth had a particular restoration on it. And then they would have them write out this anonymous statement as to, I've been a dentist in this type of specialty or a general dentist for X number of years. I looked at this x-ray for this patient, and I did or did not see the presence of a restoration on X, Y, and Z teeth. And that was really the staple of the government's investigation. Well, the government, they investigate all sorts of healthcare fraud in lots of different areas of healthcare. So they're by no means experts when it comes to dentistry. And so that was really our opportunity to scrutinize and challenge the investigative techniques that they had employed to get to a point where they had executed a search warrant on my client's office. And so what we knew is that, absent, an examination of a patient in the chair, the next best way to confirm the existence or not of restorations in this case was intraoral photos, not an x-ray. Because, we know that x-rays, there are things that can prevent being able to definitively say whether a tooth shows a restoration or not solely based on an x-ray. And so, because going back to, we're dealing with youth, we're dealing with poor oral hygiene, a lot of these patients needed orthodontic work. And one thing that orthodontists love to do is take pictures, intraoral photos. And so we started cobbling together as many of these, initial intraoral photos of these patients as we could that were in close proximity to the restorations that were now under scrutiny from the government. And we were able to cobble enough of these pictures together where it was clear that the government just didn't have a case. And so we went into this meeting and they had this big binder of these handwritten statements from the prior doctor. They had all these charts that they had made in Excel about how this doctor was a statistical outlier. And then we had pictures. And the pictures, they tell 1,000 words, whatever that saying is. A picture can say 1,000 words. And what they said was really 2 words, not guilty, because they had it wrong. These pictures clearly showed that the restorations that were billed had been performed. Now, I think in some instances there was an argument of, well, should this have been a 2-surface or a 3-surface restoration? But at that point, we had already won. And so we were able to get the government to walk away from their investigation, decline to pursue criminal charges, all based upon these intraoral photos that we were able to cobble together from these orthodontists in the area that had treated these patients subsequent to our client. And so from that moment forward, I have been such a huge proponent of practices integrating into their protocols, taking intraoral photos, because you just never know when that photo may vindicate you in some setting, not necessarily the FBI knocking down your door and taking computers and records, but it's just an extra layer of proof that a service was rendered or a particular service was medically necessary. I don't even know if I answered the question, Amanda, but that's a story that I always like to tell when we talk about dentists and being under criminal investigation.
Well, I think people are kind of here for your stories. We want to hear the scary stuff.
Yeah.
But I agree with the intraoral photo thing. That's just something that we talk a lot about practices taking to help with insurance claims getting
Yeah.
covered and things. So
Or even just to show the patient,
yes,
like, here's what
Totally.
I did. And then if they do have terrible oral hygiene and they come back 6 months later and have more decay somewhere, you can say, well, looked good when I finished it 6 months
right.
ago.
Exactly.
Should have laid off the Mountain Dew, I
And
suppose.
meth.
Yes.
Ugh.
Yes.
Yeah.
Mountain Dew and meth. Yes.
Minor detail.
The Medicaid
Uh,
offices have always been a little bit tricky. Not all of them, but definitely we had, some discovery calls with potential clients. And as we're digging in, we're noticing some weird things. Overbilling,
mhm.
your production is $7 million, but you're collecting below $1 million,
Mm.
or
Mhm.
or billing everything under the sun for like 3-year-olds, like FMX. Who's taking an
Yeah.
FMX on a 3-year-old? It just
Mhm.
so you see a lot of things like that. And I hate to say that you kind of see their side of things, because that's maybe not how I want to word it. But here you are, you're being a great dentist, you're offering dentistry to people who otherwise could not afford it, and you're being paid so minimally for it. And here's this carrot to dangle where you start tacking
Right.
on some extra codes to get a little extra money in your pocket. And it's hard for them to not, take that carrot,
Mhm.
but you can't. Bottom line is you just can't. I mean, they need to know that going in. And I think sometimes, again, you don't know what you don't know. And all of a sudden you're a Medicaid provider and you're feeling the heat and you're working yourself to the bone. So it's tough.
Oh, it's a very challenging area. I'm very thankful that there are dentists that do want to treat that community because it is such a need. And the system is flawed in that regard. It shouldn't be those practices that, get paid the least in some instances, but face the most scrutiny.
Mm-hmm.
But that's the system
Mhm.
that we live in. And so you just have to know that if that's the business decision that you make, where, you're always, generally speaking, going to have plenty of patients to treat, you just have to know and really be on top of your documentation and record keeping practices, because you are going to face harsher scrutiny and the consequences are far more severe than they may be with a PPO plan, or certainly with a fee for service. So you just have to know that and plan for it.
Yeah. I was going to say, I think most of these kind of like more crazy cases that we usually hear about or that kind of make the news are typically like Medicaid
Yes.
investigations. But would you say that you still see, plenty of investigations happening from, PPO or commercial insurance companies and plans? So don't let doctors who, if you don't take Medicaid, you're still not off the hook. Because I think I hear that from a lot of doctors too. It's like, well, we don't take any of the state plans, so I'm not too worried about it.
Yes, that is an excellent point. And I mean, you're right. When we hear about a case in the news, it's typically because, the facts are particularly egregious. And so I'll tell one of those stories. So, and this isn't the case that I represented, but a couple years ago, there was a case that made the news about a dentist in Wisconsin that was under federal investigation, and it was stemming from an audit that was conducted by, I believe it was Delta Dental in Wisconsin. And this practice was a statistical outlier for restorative procedures. And I think crowns were ultimately what prompted a referral for criminal investigation. But this doctor was intentionally damaging and breaking patients' teeth so that he could
Oh my
perform crown
gosh.
procedures. And
Oof.
it was through the audit process that Delta Dental discovered this and then ultimately referred the case to the FBI, I believe, who conducted the criminal investigation. And that individual was prosecuted. I believe they pled guilty, so they didn't go to trial. And then they were incarcerated for, I want to say it was roughly 36 months, and have a multi-million-dollar restitution order, have lost their license to practice dentistry and will never be able to practice as a dentist again. And this wasn't a Medicaid practice. This was a PPO, and it started because of an insurance audit. And that's what I like to convey to the audiences when I speak, is that, these insurance audits, they can lead to far harsher investigations. And so they have to be taken seriously. And it's not just what you may read in a Facebook comment all about the insurance company recovering money. It can have far harsher consequences, ultimately subjecting your liberty to just sleep in your own bed at night if, the conduct, it rises to that level of egregiousness. And so it's not Medicaid only. It can happen with PPOs. And so again, it's all about taking these things seriously when you're confronted with them, so you avoid finding yourselves even in an investigation, because you certainly don't want to be there, because, the greatest fear in these things are the unknown, and you can't get clarity overnight. As I said, these things can take months and in some instances years before they're resolved.
That I don't like that story. That story was like, oops, drilled this cusp right off. Sorry, gonna have to.
Yeah.
Right.
Yeah.
Yikes.
All right. So if there was just kind of one piece of advice, big or little, that you could give our practices that are listening, what do you think that would be, so that they can obviously avoid legal action, but audits too? And, what do you recommend for them and their staff to stay compliant?
Yeah. And it really, it comes down to creating a culture of compliance. And so you need to prioritize time within the schedule to self-check, to ensure that protocols are, sufficient, to make sure that everything is being done properly and in accordance with the various contracts that we have entered. And it's okay to ask for outside help when it's needed. It's okay to ask for outside help, even if you're not under scrutiny from an insurance company or a regulatory authority. Sometimes we need someone else to check us to make sure that the way our practice operates is the best that it can be. And if there are areas that we can improve in, then we should take that advice and we should improve it. And compliance can be cool, and compliance can keep you out of trouble. And again, I'll end by saying, by acting compliantly, operating a culture of compliance, it always makes putting your head on the pillow at night easier.
Compliance is cool, people.
Yes. Yes, exactly right. Make a t-shirt.
I think you might
I
have-
am going
right.
to make it a
I
t-shirt.
think you found a little slogan there. I like it. Okay, so Justin, where can our listeners find you if they need help? And obviously, I will be sure to put that in our show notes too. But
Yes. So you can find me in various dental Facebook groups. I'm not always the quickest to respond. I'm always a work in progress in that regard. I'm on LinkedIn, but our firm website is flannerygeorgialis.com. Try to spell that. So maybe just look in the episode notes. And, I'm very visible. So always feel free to message me on Facebook or LinkedIn, or, find through the website and email me. I love to have conversations and to provide guidance when needed.
Awesome.
Awesome.
Thank you so much for coming on. I think this was our longest episode yet. And honestly,
Sorry about that.
No, for good reason.
No.
I think this was like one of our most fruitful and insightful episodes. So thank you so much. And we will catch everyone on the next episode.
Bye.